This next section of our course will cover tort law. So a tort, as opposed to a crime, is a private wrong that injures another person's physical well-being, emotional well-being, their business, their property, or their reputation. And again, to distinguish a tort between a tort is a private wrong, a crime is a public wrong. The person who brings a suit will be different. In a tort, it's an individual who is harmed. I could bring a lawsuit and the cause of action can be a tort. I could bring it against someone else. In a crime, remember, a governmental body has to bring the cause of action. And the goal of a tort is to compensate the injured party for his or her loss. And another objective is to protect potential victims by deterring future tortious behavior. But remember, one action can be a crime and a tort. And sometimes if people don't recover on the criminal cause of action, they will bring a tort cause of action. And also, under the doctrine of respondeat superior, the courts will hold a corporation liable when an employee commits a tort on the job to benefit the corporation. The elements of a tort are duty, breach, causation, and damages or injury. So first is the duty. The person has to have a duty to do something or not do something, a legal duty. Okay, and then they have to breach that duty. So they can breach it intentionally, negligently, or they can be held for strict liability. There has to be causation, actual or proximate, and there has to be damages or some type of injury. All right, so this chart is in your book. These are intentional torts. I'm not going to read all this to you. An intentional tort is something that someone commits by either action or omission, and they intend to do that action. So you can read through them, but there's a couple that are just one. I would like to focus on defamation because I think that defamation is sometimes not well understood. So defamation is a false statement communicated to others that harms a person's good name or reputation. And it can be written or spoken. If it's spoken, it's slander. If it's written, it's libel. But truth is always a defense. So I can say something if it's true. Defamation is a false statement. And there's also exceptions for public figures. The Supreme Court's given journalists an extra protection of actual malice when they write about public officials. So if they write or say something that turns out to be untrue, the public official can sue them for defamation, but they can only recover if they can show that they acted with actual malice. And remember, this is only for public officials. So actual malice means that the statement was made or printed either with knowledge that it was false or a reckless disregard for its truth or falsity. And later court cases extend that actual malice standard to temporary public figures. So these are people who didn't intentionally become public figures, but just through some sort of conduct or situation became public figures. All right, and we also have the tort of negligence. So back here, remember, under the tort elements, there was a duty, which is a requirement to act or fail to act, and then there was a breach of that duty. A breach of that duty can be either intentional, negligent, or it can be strict liability. We talked about intentional. That's an action that someone intended to perform. Now we're going to move on to negligence, the tort of negligence. So negligence has its own set of requirements. There has to be a duty, there has to be a breach of that duty, and there has to be harm, and the harm has to have a proximate relationship to the breach of the duty. All right, so the duty is still the requirement to do something or to fail to do something. A breach of that duty requires a standard of care, and it requires a standard of care called the reasonable person test. And so we say, in performing this duty, would a reasonable person have done what you did? Right? It may have caused harm, but if a reasonable person would have acted the same way, you're in the clear. That reasonable person is a reasonable person in your situation. So if I'm a lawyer, so a reasonable lawyer may have done a business deal differently than a reasonable person who didn't have legal training. Same thing for an accountant or a physician or a contractor or whatever. We apply a reasonable person test that is relevant to that actual person's basically status in life and profession and knowledge. Okay, and then we have to show proximate cause. We have to show that the conduct led to the injury, and we use the foreseeable test because without the foreseeability test is kind of a backstop to liability. It says, at the time you committed this action, was it foreseeable that that type of harm would occur? Right? So an example of that, we have Damon. He drops a glass bottle on the floor. He doesn't clean it up, and it shatters. He'd be liable for any injuries caused to anyone who cut themselves on the glass. That's foreseeable. If I drop a glass bottle at work and I don't clean it up and people hurt themselves, that is foreseeable harm. However, if a freak fire is somehow caused by the sunlight magnified through the broken glass, it's arguable that is not foreseeable, right? Because broken glass doesn't typically start a fire. It's possible if sunlight comes through the window and causes a fire, but it's not really foreseeable. So that would not be proximate cause because it's not foreseeable. So again, foreseeability is really the backstop to liability. All right, and then finally, actual harm. Actual harm can be physical harm, it can be property damages, or it can be emotional harm. All right, a little more about duties of care. So under tort law, duty of care is defined as the responsibility of a person or business to act as a reasonable person would act in a similar situation. And we talked about that and what the reasonable person test means. All right, a person who violates this duty of care by acting in a negligent or reckless manner is liable then for any harm that another person suffers as a result of his behavior. People who manufacture products owe a duty of care to those who buy them, and that's product liability. And those who own businesses and homes have a duty of care to anyone who comes onto their property. So if you own your own home and somebody comes to visit you, you have a duty of care for that person, even though you're not taking, this isn't only in commercial situations. You don't have to be taking money from them. So, for instance, a clothing store has a duty of care to ensure a tear in the carpet doesn't cause people to trip. And there's a kind of a sliding scale of protections property owners offer to their visitors. Customers receive the highest level of care. So back in our clothing store example, the little rip in the carpet, if that's a commercial business, it's a clothing store, that owner is going to be liable for that. Trespassers receive little to no care. If someone breaks into my home and trips on a little tear in the carpet, I don't owe a duty to them because they're not supposed to be there. Now, somewhere in the middle is people who you invite over. They're called invitees. You owe them a duty of care. It's, of course, a lesser duty of care than you would if you owned a store and they came to your store. Negligence defenses are contributory negligence, comparative negligence, and assumption of risk. So contributory negligence says, yes, this person was negligent and it hurt this person, but the person who was hurt was also negligent. So when I think about that, the most common example is a passenger of a drunk driver. Now, if two friends went out on the weekend and they both were intoxicated and the driver was drunk visibly and the passenger knew that driver was visibly drunk and still got in the car with the driver, they are both negligent at that point. So states that have a contributory negligence statute on the books would not allow the passenger to recover any damages from the driver. Now, comparative negligence kind of goes hand in hand. States either have contributory negligence or comparative negligence. Comparative negligence is going to assign a percentage of culpability, a percentage of wrong to each person. So in my drunk driving example, if a court said the driver was 75% wrong and the passenger was 25% wrong, then the passenger could recover 75% of their damages rather than all of them. But they wouldn't lose out on the entire recovery because they were also somewhat negligent. Assumption of the risk is just what it says. The injured person was aware of the danger involved in a situation and by his or her actions still participated in whatever dangerous activity there was. So if you go to a baseball game and you sit fairly close and you get hit by a foul ball, we would say that you assumed the risk. They're not liable to you for your injuries because you assumed the risk by going to the baseball game, sitting so close. You knew that was a known risk. Strict liability is the third way that you can violate your duty, right? We talked about negligence. We talked about intentional torts, violation, using an intentional act, negligence. Now we're moving on to strict liability. Under strict liability, an action is so inherently dangerous that even if someone didn't act negligently, they're still liable for the harm. So they don't even have to be negligent to be sued and to be found liable. There are quite a few examples of this. I've listed 4 here. So first is wild animals. If you have a pet tiger and that pet tiger hurts someone, you're liable. Even if you had that pet tiger chained up in your backyard, you're still liable. It's very dangerous. Livestock. So animals that are generally kept as an asset rather than a pet. That's what livestock is defined as. If you have that, the owner is liable for any physical harm or damages caused by an animal's intrusion onto someone else's property. So this might occur when cattle breaks through the fence and goes through the neighbor's crops, eating them. It might occur when a passing car hits a horse that's come through a fence. It might occur if you don't notify neighboring farms of diseased animals and it injures their herd. Another category is dangerous animals. You could be strictly liable for any injuries or damages caused by the animal, even if you're not at fault. So dangerous animals are usually thought of as dogs, right? Dogs kept for fighting or protection. We think of pit bulls and Rottweilers as dangerous, but it's not only dogs. It could be animals that the owner knows are dangerous, right? I have a house cat. It's known for attacking small children. If I invited small children to my house and it attacks that child, well, I'm strictly liable. If I have a parrot, it's not social. It's previously attacked a visitor with its claws and it does it again. So it's not the species or breed that matters. It's the known propensity for violence that matters. Another category of strict liability is product liability. A seller is going to be subject to liability for a product sold in a defective condition, and a defective condition is an unreasonably dangerous condition to the user, the consumer, or the property. Liability is going to extend to the producer of the product, the wholesaler, and the retailer. And the seller or producer must be engaged in the business of selling such products. In addition, the product manufactured or sold must be expected to reach the ultimate consumer without substantial change in the conditions under which it was originally manufactured or sold. And this is kind of a simple overview of product liability. It's actually a really complex area of the law. We can also have cyber torts. Just like cyber crimes, it's the use of a computer to commit a tort or committing a tort against a computer. So it's the invasion, distortion, theft, falsification, misuse, destruction, or exploitation of information stored in or related to electronic devices, including desktop PCs, laptops, mobile phones, mainframe computers, phone cameras, PDAs, and home computers that stand alone or are part of a computer network. And your book lists different types of cyber torts. I'm not going to read that to you again. I know you can read. But damages from cyber torts usually are not physical because obviously we're not in the same place. They're usually not physical. They're usually either reputational. So somebody put something on the internet that isn't true. It's very harmful. It harms your reputation. Emotional, financial, or mental. They instill fear. And then remedies to torts. So if you have been convicted of a tort, these are the things you may have to do. You are either granted damages in recovery or an injunction. Damages are of 3 types. The first is economic compensatory, and that's when you have quantifiable injuries. So I am hurt, I can't work, we know how much I make, we can quantify, we can add up my damages for how long I can't work. Or I have medical bills, I have the actual bill, so I can add that up. There's also non-economic compensatory. These aren't as easy, you can't just add them up. These aren't as easy to quantify. This might be mental anguish. It's hard to assign a dollar value to that. And then there's punitive or exemplary damages. Punitive means punishment. So these damages are intended to punish the actor, the tortfeasor. A lot of times in particularly egregious cases, you'll see courts award economic and non-economic compensatory damages. So they add those up, they award those. And then to punish the tortfeasor, they'll also award punitive damages that are some multiple of the compensatory damages. So they might say 3 times punitive damages. So they'd add up all the compensatory damages, multiply by 3, and those would be the exemplary or punitive damages on top of what they already recovered as compensatory. Another type of remedy is an injunction. So if the tort is ongoing, if it's something that is a continuing problem, right? So it's, there's a factory and they emit this odor all the time, compensatory damages aren't going to work if the odor is still emitting. We need an injunction. We need to tell this person to stop doing what they're doing. Injunctions are less likely, they're the least favored remedy. So if a person can be compensated another way, we don't want to force people to act or fail to act. But if that's the only way to prevent the harm, an injunction would be issued.